multiple questions being raised both over the manner in which the police have arrested these young activists and are going after, in fact, more activists, and also the manner in which she was sent to police custody. I'm joined by Rebecca John, senior lawyer, criminal law expert, who joins me from New Delhi. Rebecca John, now you've put out a post where you've been very critical about the manner in which all of this arrest and all that was conducted. You perhaps had a chance to hear the Delhi police. They say that all rules were followed, but you remain unconvinced. What exactly are your problems or issues with the manner in which all this was done?
Yes, Srinivasan. Now, there's a lot of fact and there is a lot of fiction. So let's try and separate them. Fact, this young woman was arrested on Saturday evening. Fact, she was produced before a magistrate in Delhi yesterday, that is Sunday, in the afternoon. Fact that a legal aid counsel was present at the time of her remand, not her counsel of choice. Fact, she was remanded to police custody for 5 days. Now, I am critical of this for the following reasons. I oppose weekend arrests and productions. I believe the Delhi police could have waited for a Monday arrest and a Tuesday production. By producing an accused person on a Sunday before a duty magistrate, you're basically ensuring that her legal rights are compromised, because it is very difficult for lawyers to be present. Most lawyers don't even know that their clients are going to be produced in court on a Sunday. Secondly, in this case, it appears that the Delhi police did inform her lawyer of choice. However, I can tell you from my experience of being a criminal lawyer in Delhi for the last 33 years, there is this cat and mouse game which constantly happens between the police and defense counsels, where defense counsels are never really informed about the time and place where the production will take place. And I think that confusion yesterday as well, and that is why the lawyer of choice could not be present, and that is a serious problem. Now, once you've informed a lawyer of choice, there is no reason why the court could not have asked this young lady whether she wanted that lawyer of choice to be present, and information could have been sent that we are now commencing remand proceedings. These are not difficult things to do. This happens every day. One. Number two, the manner in which she was brought to Delhi is also problematic. She was arrested in Bangalore. And while I completely agree with the Delhi police that there is no mandate that a transit remand must be taken from Bangalore to have her produced in Delhi, but it is the spirit of the law. So they have not violated the letter of the law, but they have certainly violated the spirit of the law. And I would like to remind the Delhi police that there is a December 2019 division bench judgment of the Delhi High Court, and the Delhi police is bound by that, where in exactly similar situations, the Delhi High Court laid down guidelines for production of accused persons from outside the jurisdiction of Delhi. And the Delhi High Court stated, and I quote, "The arrested person must be given an opportunity to consult his lawyer before he's taken out of the state." Was this done? Perhaps not. Two, endeavor should be made to obtain transit remand after producing the arrestee before the nearest magistrate, unless exigencies of the situation warrant otherwise. Was this done? No. What were the compelling reasons that you did not produce this young lady before the appropriate magistrate in Bangalore? And if there were compelling reasons, did you inform the magistrate in Delhi that this was the reason why we did not obtain and get transit remand from Bangalore? Another problematic aspect of this whole case. And the Delhi High Court goes on to say that the magistrate before whom the arrestee is produced must apply his mind to the facts of the case and should not grant transit remand mechanically. He must satisfy himself that there exists material in the form of entries in the case diary that justifies the prayer for transit remand. So the Delhi High Court is in fact reinforcing the fact that if you are arresting someone from outside your jurisdiction, you must take transit remand, and you must at least put forward your case diaries before the transit magistrate. And
so that is
cases made out of transit remand.
So that is the problem with the absence of the transit remand and the manner in which she was brought from Bangalore to Delhi, and also, as you mentioned, the problem with this whole weekend arrest business, which leaves the lawyer in the lurch, so to speak, that you're not able to get that information, you're not able to be there. But let me also ask you about the fact that she was ultimately then remanded or sent into police custody for 5 days by a court here in Delhi. And in the remand order, the court says that the police, justifying their need for police custody, say because they wanted to recover material from a deleted WhatsApp group and other devices and mobiles, that for proper investigation, her detailed interrogation is required to get information by the pro-Khalistani group and their active members, and so on and so forth. Are these, without getting into too much of the nitty-gritties, are these justifiable reasons to remand a 21-year-old for 5 days to police custody?
Now again here, Vasu, there are two things. The law allows the magistrate to remand an accused person to police custody for a maximum period of 15 days in the first tranche. So remanding her for 5 days is not an illegal order. So we are not talking about illegalities here. I'm talking about proprieties. My entire conversation with you is about propriety, not illegalities.
Yes.
Now, was it right for the magistrate to remand her for 5 days at a stretch? I would say that it would have been better if a duty magistrate, if he felt that there was a case of remand that was made out, remanded her to 1 day's police custody and asked her to appear before the regular magistrate on a weekday, that is today, 24 hours police custody to be reviewed today. That should be the proper thing to do. If you remand somebody for 5 days at a stretch, you really do not have the kind of monitoring that is required. And perhaps a regular magistrate who is seized with the matter would be in a better position to do that monitoring.
Right.
So if a regular magistrate had remanded her for 5 days, maybe it was not so questionable, but I do believe that duty magistrates must be circumspect when they remand people for 5 days police custody at a stretch.
Right. But let me ask you the wider question here. I think what many people are still not able to comprehend is what was, because as you mentioned, this Delhi High Court talks of the exigencies, the conditions and the context in which you actually are required to arrest somebody, right? I mean, there are many ways of getting information. Why do you have to arrest, to bring somebody from Bangalore, send them for 5 days? That's what I'm trying to understand. That is that a context? Is that a factor which is increasingly being violated by the police?
I think we are becoming increasingly trigger happy here. It never used to happen in the earlier years of my career as a criminal lawyer. Arrest was inevitably a last resort option, and only after somebody failed to participate in the investigation, or if somebody absconded, or if somebody was concealing material which was necessary, was arrest made. In any event, an arrest should be made after you've collected sufficient material. It appears to me from the way this order has been dictated that they are looking at collecting basic essential material. Efforts to be made to recover deleted WhatsApp messages. Now, what will you do with her for 5 days which will help you get back deleted WhatsApp messages? That is a conversation you'll have to have with WhatsApp or with the forensic experts. This lady will not be able to help you do that. Then other devices, mobiles which were used. Now, surely you can get all of this information even if she's not in your custody. So I think we need to relook our laws. You know, too much is happening these days. Too many people are being taken into custody. And ultimately, it is personal liberty. Here are citizens of this country who are being arrested prematurely. I'm not saying that ultimately a case of arrest may not be made out. In a given case, you may collect material and you may be able to arrest somebody based on robust material. But to do this prematurely, send her in for 5 days police custody when you haven't even got basic material with you, I would say is very problematic. I also want to say something, Vasu, here. Way back at the time when Justice H.R. Khanna gave his iconic dissenting judgment in ADM Jabalpur, he used a very interesting line. He said the history of personal liberty we must bear in mind is largely the history of insistence upon procedure. And that is what I'm talking about here. Procedural law is central to, and adherence to procedural law is central to personal liberty. And unless we insist on adherence of procedural law, we really will land ourselves in great trouble.
Okay, Rebecca, John, thank you so much indeed for that. Thanks very much.
Thank you.